And a black couldn't go to Rutgers either.
Well, that's absolutely right. And so I think, society has changed, and society will continue to change, as will the courts. And I think there are those who would like to speed up change on the courts, and then some that perhaps find that troublesome. Yes, ma'am.
I don't know if this is exactly relevant, but I was wondering how the state of Kansas could ignore separation of state and church by having something like the intelligent design taught in schools. Was there any, I imagine there must have been a group that protested that, but I never heard of any outcome.
Well, Kansas isn't the only state where folks have tried to get something like intelligent design on the curriculum, and I think that a number of the initial attempts to do that were beaten back, and there's sort of a repackaging of a creationism theory to look more like a scientific alternative hypothesis, and ultimately some of these things are going to have to be played out in the political dynamics, which is to say that if the people, if a significant number of the people in the state feel that should be on the curriculum, and it's recast in such a way that it fits within the scientific method as a scientific theory, the courts are going to be reluctant to be the ones to say, no, you can't have that. Courts have to make unpopular decisions, and they have throughout history put their foot down in places where the political winds of the day would make that a very difficult decision to make. But I think some of these curriculum matters in the schools, unless and until it's a particularly egregious example of an obviously religious agenda being put onto the curriculum, it's going to be difficult for courts to stamp that out every time. I don't know if that answer is helpful, but...
Do you want to make this the last one?
Sure. One last question, that'd be great.
Is the Brennan Center involved in the current case from the Supreme Court about the Hillary Clinton film sponsored by a corporation and speech?
We are not involved directly as one of the parties in the case, but we have been very involved in following it, and we have submitted some friend of the court or amicus briefs in the case, or a brief in the case. For those who may not have followed this closely, I'm glad you asked that. It's an excellent question, and I'll try and address it as quickly as I can. There's a movie called Hillary the Movie, which is a movie that was created before the election last year, before the primary election last year, and which the FEC, the Federal Election Commission, said could not be aired on on-demand cable within 60 days of the election because it was an electioneering communication and it had been supported with a corporation's money. The McCain-Feingold law puts certain restrictions on using corporate money to influence elections. Now, corporations are allowed to set up PACs, but they can't spend their money directly. At issue now before the court is whether those restrictions should be thrown out and corporations should be able to spend as much money as they want on whatever advertisements they want to run in the days immediately prior to an election. The concern, one of the many concerns about this, is that if the Supreme Court says open the floodgates, let corporations have as much right to speak as any human being, they should be able to spend their money whenever and however they want in the days right before an election, that corporations, which can amass greater money than many individuals, will have a disproportionate voice and will be able to drown out the voices of ordinary citizens. There are, very heated and passionate advocates on both sides of the issue. We have taken a position that we think these restrictions on corporate money serve a salutary purpose in our democracy, and that to let corporations dominate political debate could lead to some unpleasant and unintended consequences. It does not seem that is the prevailing opinion in the justices of the Supreme Court, so there is certainly a belief in many quarters that they may open the doors to corporate participation in elections. We will wait to see how that plays out. I talked earlier about the trends of increasing money in judicial races, and particularly increased money spent not by the candidates themselves but by outside groups. And if that case is decided, one of the aspects of that case that hasn't been talked about quite as much is the impact it could have on judicial elections. Because corporations may decide, you know what, it's a lot easier for us to buy 4 seats out of a 7-judge Supreme Court than it is to get 112 seats out of a 250-person legislature. We only need to buy 4 candidates, and they may decide it makes a lot of economic sense for them to pump a lot of money into judicial elections. So we're going to have to follow that very closely. Thank you all. I'm sorry we're out of time, but thank you all very much for having me today.